Good day everyone, my name is Mariel Abanes and today we are going to discuss about intellectual property rights and computer technology. So what is intellectual property rights and computer technology? It is IP for short and describes tangible things. If you say tangible things, this is such as ideas, inventions, technologies, artworks, music, and literature, to which one can claim ownership. Ownership of IP may result in economic gain as rewards to personal initial investments. The monitor, keyboard, mouse, CPU, and printer are the parts of computer that you can see and touch, or tangible things. A service is an act carried out usually by the customer. Services have intrinsic value to the customer but has no tangible form.
Hello, my name is Jet Escobedo, Visayas. Hello, my name is Jet Escobedo, Visayas A 2021. Today we're gonna talk about copyrights and software piracy. So, copyrights internationally, a copyright is a right enforced by law accorded to an inventor or creator of an expression. Such expressions may include creative works, literary, dramatic, musical, pictorial, graphic, artistic. So, copyright, no? Meron 'yan. 'Pag gumawa ka ng isang work, sabihin nating libro, music, ano pa ba, siguro art, meron kang ilalagay na copyright na palatandaan para palatandaan na sa iyo 'yun, sa iyo lang yung gawa nun para hindi manakaw ng iba, hindi makopya ng iba. So, move on tayo sa software piracy. Software piracy, discussing the intellectual property rights or IPR, one cannot fail to think about modern wonder of technology, the computer software and its relationship with IPR. The biggest problem concerning computer software and IPR is software piracy. So, ang example ng software piracy, sabihin natin, Microsoft Word, parang dinaload mo lang, di mo binayaran. And yung di lang yun, meron pang games, siguro games, kahit anong software na dinaload mo pero di mo binayaran, tapos ginamit mo. Yun na yung example ng isang software piracy. So, yun lang sa software piracy tsaka sa copyrights. Once again, my name is Jet Escobedo, this ISA 2021.
Public domain will receive the copyright when it is already expired. Other works in public domain include those owned by the governments. So how to process a copyright? The process begins with an application to the Copyright Office, but remember that each country's Copyright Office has different requirements. But in US Copyright Office, they requires an applicant to include with the application a copy of the work for which a copyright is sought and to file for copyright within 3 months of the first distribution of the work, upon receipt of the application by the Copyright Office.
Duration of copyrights. In the United States, the duration of copyrights protected falls into two periods. Those copyrights granted before 1978 Act and those granted after the date. If a copyright was received for a published works before 1978, that copyrights last 75 years after the date of issue. For unpublished works, the copyrights will expire on December 31, 2002, regardless of when they were issued. If the copyrights were received after 1978, the work remained protected by copyright law for the lifetime of the author plus 50 years in the case of more than one author of the work. The protection lasts for the lifetime of the longest author plus 50 years for all works made for hire, that is, work made as a part of contract employment. The conversion lasts 75 years from the date of the first publication or 100 years from the date of creation. Copyrights protected shall last 50 years from the date on which the work was first lawfully published. If the work was not published, it should be protected for 50 years counted from the creation of the work. Patents. In contrast to the copyright, which protect expression, patents protect invention or discoveries. In the United States, patents rights are protected just like copyrights. In many countries, patents protect protection rights as are those of copyrights are provided for by the Constitution. The U.S. Constitution, for example, states it this way to promote the progress of science and useful arts by securing for limited times to authors and inventors for exclusive rights to their respective writing and discoveries. In accordance with this, Congress has enacted and continually revised patent law to suit the times. This law gives inventors or discoveries living within the U.S. borders and territories the exclusive rights to make use or sell their invention or discovery for a specific period of time, so long as there was full disclosure of the invention or discovery at the time the patent application was filed. A patent is an exclusive right granted for an invention which is product or process that provides in generally a new way of doing something or offer a new technical solution to problem. Application for a patent. In many countries, the process of obtaining a patent begins with the filing of an application with the patent office. As we already discussed, the application must give a clear and detailed disclosure of the invention or discovery, including its working, experiments made, data used, results obtained, and safety record and effectiveness if used properly, its weaknesses if observed, and all pertinent information that may be required if the patent office is to carry out similar experiment must also be submitted. It is intended to be written for a person of ordinary skills in the relevant field of technology to the invention and application, therefore does not need to be a manufacturing blueprint, since many minute details of particular machine are not necessary to the invention that is not incorporated into the machine. Duration of patent. After the review process is completed, and this may take some time depending on the disclosure provided and the type of invention or discovery, the patent is then issued to the applicant for invention and only for the invention, not including its variation and derivative. The protection must last for a number of years, 17 years in the United States. During this time period, the patent law protects the inventor or discoverer from competition from other in the manufacture, use, and sale of the invention or discovery. Patents right lasts only for a limited period, and the right to the other parties for patents owner may want to calculate the expiration date of their patent. This will depend on the filing date of their patent application as well as the type of patent that they receive.
Public domain. The patent law does not protect ideas, but only the process of carrying out an idea. Competitors may take the same idea and use a different process to arrive at their own inventions or discoveries, which can then be patented as novel. When the patent protection expires, the patent together with all disclosures go into the public domain for anyone to use. The public domain includes every creative work that is no longer protected by a copyright, trademark, or patent. Creative works that are no longer protected are owned by the general public rather than the original creator. As such, the work is free to be copied, performed, or otherwise is used by anyone. Trade secrets. A trade secret is information that gives a company or business a competitive advantage over others in the field. It may be a formula, a design process, a device, or trade figures. Thus, there is no one acceptable description or definition of trade secrets. The generic definition is that it is a collection of information in a given static format with a strategic importance. The format may be a design expressing the information, a formula representing the collection of information, a pattern, a symbol, or an insignia representing the information. Whatever the format the collected information takes, it must have given or offered an advantage to the owner which places that owner a degree above the competition. Or service. In the United States, in contrast to the other intellectual properties we have described so far, trade secrets have no federal protection. All trade secrets laws are very well known that consumers tend to choose between products. Trade secret owners are further protected by for express or the golden arc is a trademark laws and laws. There are many other fast food restaurants which are backed them by can use the golden arc as their trademark. What is a trade the golden arc differentiates is information such as a formula from all other fast food restaurants compilation program and device an advantage over its competitors or process that derives industry a unique and significant value because trademarks are used by consumers to choose among competing products. They are vigorously protected by their owners, differing from patents and copyrights. However, trademarks are not so protected and enshrined in constitutions. At the federal government level, the trademark laws can be found in the Lanham Act and the new Trademark Cyber Prevention Act 1999. What is a trademark? A trademark can be any word, phrase, symbol, design, or a combination of these things that identifies your goods or services. It's how customers recognize you in the marketplace and distinguish you from your competitors. The word trademark can refer to both trademarks and service marks. A trademark is used for goods, while a service mark is used for services.
Registration of trademark. So what is registration of trademark? An application for a trademark must contain and present all relevant information. It must also describe the product or service from which the trademark is being sought, the class of goods and services, and the date of issue of the mark. Marks are registered only if they meet certain criteria. The core requirements is the mark must cause confusion with similar mark used by others.
Identity theft is a crime in which a person pretends another person, even without a success, in order to get the victim's information. Identity theft has become one of the most common crimes in the United States, as well as in a number of other countries. It is incredibly difficult to clear one's record after being a victim of identity theft, let alone regain the stolen personal information. But there are steps to consider that is effective. One is shred all credit card receipts, cancel checks, and other financial documents. Next is seek employer personal information protection plans. Next is periodically check your credit report.
Ownership. As we discuss ownership in this section, and indeed the whole book, we confine ourselves to intellectual property ownership. Ownership of everything else other than intellectual property is outside our present scope. An idea, it's novel, if it's original or aesthetic and new. Inventiveness, creativity, and discovery are born of individual ideas. Good ideas are the source of substantial benefits to individual and the public. Before an idea can be useful, however, it must put utilizable form either as process or an application. It is the idea is utilizable form that is the core of intellectual property rights. In many countries, the owners of such an application for the idea has a set legal rights to its expression as creation, work, invention, discovery, information, or any other form.
Much has been published recently regarding intellectual property rights, and the topic has been in the headlines, such as when the United States government negotiated with China, which many in the West believe has the highest rate of intellectual property law violations. Regarding the topic of intellectual property rights, many statements have been made about the effects of cultural differences.
Psychology of ownership. Whenever we grow up in culture that rewards individual achievements, or in those culture that pride themselves community achievements, we are aware of this strict psychology about individual ownership. We tend to classify those items that we individually own whenever they are few about or abundant. According to intrinsic value to us, we may believe our self-worth and status in the community depend on the intrinsic value of item we own. So all the intrinsic value we attach to this item is one of most important aspect of ownership. Another aspect of ownership is tangibility of what we own. When what we own has tangible, ano ba to?